inquiry session, nomination session, sorry. I shan't ask if you can hear me, but do.
Sorry, I think Mr. Boulier, you appear to be on mute at the moment.
How about that? Is that better? Yes, thank you. That's a good start. Apologies. Yeah, my name's Mr. David Boulier. With me is Mr. Stuart West. We are reporters within the Scottish Government's Planning and Environmental Appeals Division, commonly known as DPEA. We've been appointed by Scottish ministers to conduct a public inquiry into a proposal for the construction of an 18-hole golf course, practice area, access parking and ancillary development, including the change of use existing buildings at land 1,700 metres northwest of Embo Community Centre, commonly known as the Cool Links proposal. Purpose of today's meeting is to sort out arrangements for that inquiry procedure. It's not to discuss any of the merits of the proposal. That will come later on in the year. I'm aware that many of you have participated in numerous public inquiries previously. I recognise some of your names from the last inquiry into this case, which colleagues of mine dealt with. So I apologise to you if I explain in a bit too much detail the background to what we will be doing today and subsequently. But for the benefit of those who don't have such experience, I'll explain a few things in a bit more detail than some of you perhaps need. After today's meeting, we'll be issuing a note of what we've discussed and agreed, and that will also contain a link to the recording of this session, so you can always go back if you wish. So you don't need to hopefully take too many notes as we go along. In the interests of clarity, if you can keep your microphones off except when you need to speak. Similarly to cameras, I think we seem to be okay as far as I can tell in terms of broadband wise with those of you who have your cameras on, so that's fine. But if it starts to break up or get choppy, we may need to switch cameras off. We're fine as we are at the moment. So as I said, the purpose of today is not to discuss the proposal in any detail. It's to simply arrange dates and times, hopefully, and the type of procedure that we will be employing to discuss the proposal and enable Mr. West and I to write our report for ministers who will ultimately determine the application. We have some discretion as to what procedures we follow, whether it's written procedure or some form of oral procedure, possibly involving cross-examination. We gave some initial thoughts in Appendix 1 to the agenda for this meeting as to where we thought or how we thought that might work for different topics. I have to say we've probably ourselves evolved our thinking since then, so it may not reflect our current position necessarily as we've read more into the case. And obviously you will all have your own views as to what you think needs written procedure, oral procedure, etc. And we'll come to that later on in the meeting. Before we get onto that, though, I think it'll be helpful to ask those who are going to speak today, either for themselves or who are representing any of the groups or parties that are involved in the procedures, to introduce yourselves. I'm going to go down in the order that was set out in part 2 of the agenda. So the first person I'd like to hear from, please, is who would be speaking today on behalf of the applicant, NA-270-010-Coul Limited.
So that will be myself, James Finley, King's Counsel, instructed by Nicola Drummond from Nest Planning. Nicola Drummond and Gordon Sutherland are also on the call.
Thank you, Mr. Finley. And on behalf of Highland Council?
Yes, sir. Alistair Burnett, King's Counsel, representing Highland Council, instructed by Rhoda Banfro, solicitor at Highland Council.
Thank you, Mr. Burnett. And Nature Scott?
Good morning, sir. My name is Peter Ferguson. I'm a solicitor with Hong Clouds, and with me, albeit virtually today, is Alec from Nature Scott.
Thank you, Stacey. Do we have someone from Dornoch Area Community Council?
Yes, good morning. My name is Jerry Bishop. I'm a former community councillor, but I was the person who moved the motion which was eventually submitted on behalf of the community to the planning application.
Thank you, Mr. Bishop. And there's I think I had it in the agenda as RSPB Scotland, but I know you have a consortium of community groups. Can I ask who's speaking on behalf of them?
Yes, sir. Good morning. I'm Louise Coburn. I'm an advocate at the Scottish Bar. It might make things simpler, sir, if I give you now the list of the members of what we're calling the Conservation Coalition, if that would help.
Please.
So that's made up of RSPB Scotland, BugLife Scotland, the Butterfly Conservation Scotland, Plant Life Scotland, Marine Conservation Society, National Trust for Scotland, and the Scottish Wildlife Trust. And there are three people on this call. Sitting beside me is Esme Cleland of RSPB Scotland, Rosie Sutherland, and B. Ailing, also of RSPB Scotland, are sitting virtually.
Thank you, Mr. That's helpful. Do we have someone from the Royal Dornoch Golf Club?
Yes, good morning. I'm Neil Hampton. I'm the General Manager here at Royal Dornoch.
Thank you, Mr. Hampton. Anyone from Green Action? Not Cool. Do we have a spokesperson for Not Cool?
Yes, good morning, sir. Simon Crabb, advocate on behalf of Not Cool. I'm tuning to John Campbell KC, who is not available today but is involved in the case, and Dr. Tom Dargy is also on the call today.
Thank you. Right, so are there any other groups that I haven't mentioned are present? I'll do groups first, then individuals. Anyone speaking for a group?
Good morning, Mr. Booyer. Jim McGilvey here, councillor for East Sutherland and Edgerton. And at the last one, I represented, or I was front of house for a number of individuals, former prophets of the Royal Band of Dornoch, speaking in favour. So as a community alliance, I will probably be the front of house for.
Thank you.
I'll come up with more names later, please, if that's okay with yourself.
That's totally fine. Yeah, that's totally fine. Any other groups before I go on to individuals? No. Okay. Anyone who's speaking on their own behalf or may wish to speak on their own behalf, would you like to introduce yourselves?
Oh, there's a couple of hands up.
Okay. Yeah, so I've got Mr. Batten, I think, with a hand up.
That's correct. Peter Batten, sir. Good morning.
Morning.
Sorry, I'm just getting my script from the right set of notes here. Right, I'm a North Highland, though not a Sutherland resident, with a history of participating in DPA inquiries since 2013, including Mr. Bouillier, a case of your own in 2017. I participated in my own name on policy and statutory guidance at the 2019 Coul inquiry, and it's my intention, as things stand, to do so again, subject to the outcome of this morning's meeting. Briefly, you asked about Green Action.
Yes.
I actually have some information about that, though it's not me. I understand that Green Action is a grouping of a large number of emails to the Planning Minister, which were curated via the Scottish Green Party's website. For my suspicion is that Green Action may not be a party for the purposes of the inquiry, unless anybody else knows otherwise.
Thank you, that's helpful. I did recognise your name, Mr. Batten. That may explain why. Ms. Wilson, I think you were next with a hand up.
Yes, good morning, Dr. Joni Wilson here. Resident of this planet, very concerned individual, not representing any groups or organisations, but I am a member of a number of environmental campaign groups. Thank you very much.
Thank you. Mr. Jones.
Hello, good morning. Just to say, I'm also a local resident. I filled in my application to be part of this. I can't remember if I disclosed, but I do work for Plant Life Scotland, but I'm doing it independently as a local resident, and my views won't represent the organisation. If there's any issues, though, let me know.
That's fine. That's totally fine. Thank you. Anyone else? I think that's everyone. I'm terrible at spotting hands. I'm going to be prompted by my colleague. So, Mr. Fulson, I think, do you have your hand up?
Yes, I do. My name's Alan Coulson. I'm interested to join this exercise purely on an individual basis, although in the interests of revealing information, my daughter is an employee of one of the organisations previously mentioned.
Thank you. Anybody else? I think that's all of us. Yes. Okay. We're aware that there's some people who indicated via the opt-in procedure that they might want to take part in the inquiry but couldn't be here today. They will get a copy of the note of this meeting, and so they certainly haven't missed the boat by the fact they couldn't be here today. It's the trigger, if you like, for participating in whatever procedure we agree is to come later. Will be responding to the note of this meeting. You'll have 14 days to do that. And as I say, it will go to everyone's document, not just yourself. Item 3 on the agenda was code of practice for handling inquiries. Slightly strange that we actually get quite few public inquiries these days into planning proposals. So the most up-to-date guidance that we have as Scottish Government for how these things work is actually in relation to proposals under the Electricity Act, believe it or not, wind farms and transmission lines, etc. So although the context is very different, if anyone wants to see some guidance as to how these things go about, what sort of deadlines apply, what you need to do to get involved at each stage, we've included, or we will include a link to the relevant Electricity Act guidance, which hopefully will make things clear. I'll try and explain in this meeting very briefly as well, just what the different processes involve, etc. But until we get some more up-to-date planning guidance in place, which, as I say, may not be worthwhile, given that we actually get quite few planning proposals going to inquiry, then it's the Electricity Act guidance that provides the most current picture of where we are in terms of what we expect for inquiry procedures. It's worth saying, and I'll come on to it later, but for anyone who isn't familiar and wasn't involved last time, for example, we certainly don't want to discourage any individual from taking part in the inquiry process, but it is fairly heavy in terms of administrative workload and deadlines and things. So if there are individuals who wanted to group together in order to share that burden, that might be something you want to think about. But I don't want to discourage anyone from doing their own thing. But as that guidance explains, and as I'll try and explain later, there are deadlines that you need to meet. We're fairly strict on those. So, there's a certain degree of burden involved in getting involved in oral procedure, more than just turning up on the day. The procedures about prior disclosing of the case you intend to make. I mean, you do have to put some work in advance. You can't simply turn up on the day. The possible exception to that, or a slight relaxation to that, is, and I'll come to this later as well, is for those who don't necessarily want to get involved in a technical session. We're proposing to have an evening session where anyone who wants to talk about it can come along, an evening session generally, which is less formal. We do like people to tell us what they're going to say in advance, but it can be slightly less formally done. So maybe a couple of weeks prior, they give us a document that they'll speak to, and that there's no cross-examination or anything like that. It's fairly laid back. So that's an option for those who don't want to get fully involved in the meat of the main sessions. But I don't want in any way to put anyone off from doing that. It's just that's an option if you, on reflection, find that meeting all the deadlines and submitting documents in time, etc., is a bit onerous. Getting on to point 4. So before we get to the arrangements for the inquiry, we thought it would be useful just to know whether parties think there will need to be any further submissions, and if so, whether they could be kicked off sooner rather than later. I'm thinking with 2 points really. Is anyone aware of any changes, either council or government policy, that might require an update from a policy side of things, and secondly was about environmental information. So just looking at the policy side of things, is anyone aware of anything? I'll start with the applicant really. Anything that they think might require an update to the information that we already have?
Well, so in terms of since the submission of the application, I think NPF4 came out, but in the planning statement that accompanied the application, I think there was reasonably lengthy submissions on the draft policies, which to a greater extent were taken forward, and the Highland Council report dealt with NPF4. So in our view, there's no need for any further update as such, save insofar as you'd like it, but when that's the only policy that might tick that particular box.
Thank you, Mr. Finlay. Anyone disagree with that? I think that probably accords with what we're thinking. We weren't aware of anything pressing that we would require an update. No, good, thank you. In terms of environmental information, I note from what I've read so far, I'm probably looking at Ms. Coburn next, in terms of, and apologies if I'm not fully read into the case, but there was comment from RSPB, I believe, about lack of cumulative assessment in relation to some holiday lodges, I think, and I just want to try and get to the bottom of parties are putting any further environmental information in as to whether that's going to come now rather than later, just so we can avoid prolonging the procedure and we can get any necessary publicity done, etc. I don't know whether I'll ask Ms. Coburn as I put you on the spot first, and I'll come back to you, Mr. Finlay. Are you aware of that, Ms. Coburn?
I'm not. I'm getting a note scribbled to me about it, and if you would give me a couple of minutes, perhaps I could take some instructions and revert to you, and perhaps be of more help than currently. I wonder, though, if I might come back to you about the question of additional policy and guidance that the reporters may wish to consider having perhaps written submissions on. Doubtless, sirs, you'll be aware of the Scottish Biodiversity Strategy, and the consultation closed on the 14th of December last year. There's also the Scottish Government draft planning guidance on biodiversity and the Scottish Biodiversity Strategy post 2020, a statement of intent. I don't know, sir, if those were also within your contemplation, but certainly those instructing me would wish me to raise the prospect of written submissions on such as those documents, and in addition on NPF4, particularly given the importance of Policy 3 to this application. I've had a short note given to me. Apparently, there was not a full cumulative assessment that was undertaken when the holiday lodges were granted, but perhaps something that I could take away and respond to you, or those instructing me can respond to you in more detail if that would help.
Thank you. It's really the stage. If, and I'll coming back to Mr. Finlay in a second, if it's obviously it's up to them ultimately, but if they think it's something they wanted to address up front, then that would be useful to know now. They may not be intending to address that. They may not think they need to address that. Are you aware? You may not have instructions on Mr. Finlay, and putting you on the spot now, but is that something you're aware of? Is that standing question over whether the adequacy of the EIA in terms of cumulative?
It's not something that I am aware of, and not something that certainly been raised in discussions yet. So it may be best if Ms. Coburn sets out whatever she thinks, or you set out your concern as to that, then we can take a view, but we certainly haven't formed a view on that yet. In terms of the other matters, it may just assist. I've no objection to written submissions on those policy documents to which Ms. Coburn referred.
Thank you. We'll come to that question about procedure and policy. The other note I just noticed that I had, there was also a question mark on the question of effects on the integrity of the SPA with regard to bird surveys. And again, I'm not saying that either that or the EIA cumulative question are points that I formed any views on at all, because I haven't, but that was another question mark that cropped up. So you don't need to answer that now, Mr. Coburn, but maybe if that again is an issue that you think is important to your case, it would be good to know that ASAP so Mr. Finlay can take instructions. We've still got time if any extra work needed to be done prior to getting to any inquiry session, potentially. So yeah, just if it is to be a thing, you know, if you could take instructions and let us know as soon as you can, and then we can program that in if indeed Mr. Finlay thinks it's necessary to address that.
I will take instructions. We'll discuss this after this pre-examination meeting, and those instructing me will send to the case officer a note setting out the position, sir. And I'm sure that that can be capable of being done certainly by close of play tomorrow. I don't anticipate that this is going to be a particular stumbling block.
Wonderful, thank you.
We have one hand.
Okay.
Yes, thank you, sir. Mr. Craft from NA-270-010-Coul. Just one point in respect to the additional information. There is one outstanding document which those instructing me consider would be irrelevant. I think that's a document that's held by the applicant. It relates to, I think there's a 1-page letter, a 4-page summary, and a 60-page full document. I think this was submitted to the individual members of the National Planning Committee at the time of the debate about original planning and permission. So if that could be disclosed in our submission, that would be of assistance.
Yeah, thank you. Okay, thank you. That's helpful. Mr. Batten, you have your hand up, I think.
Right, can you hear me there?
Yes.
Yes, good. Okay. Yes, Ms. Coburn mentioned, I think, the biodiversity planning guidance issued in draft by Scottish Government last November, if I remember correctly. Are you aware that there's also been a biodiversity planning guidance document from Highland Council, which I understand was adopted, I think, at the beginning of this month, possibly the 2nd. And I don't know whether that's considered relevant by any parties, but as it's new, I thought it was worth flagging it.
Thank you. Ms. Coburn's nodding. That'd be something you also.
Yes, that's my apologies. I've missed that off the bottom of my page. Yes, it was adopted on the 2nd of May 2020, 2nd of May 2024, I think. So very recent. So yeah, if that could be added to the list, please, I'd be very grateful.
Certainly. Mr. Crabbe, do you still have your hand up or not? Thank you. All hands, I think. Yes. Yep. Wonderful. Thank you. Okay. Point 5 on the agenda, which is where we actually get down to talking about what we're going to be doing and how we're going to be doing it. Listed, as I said, in Appendix 1 to the pre-examination meeting, areas where we thought the evidence might be, or how it might be divided up. This was based on a very initial look at things, and also the procedure by which we might consider that evidence. The first issue you may have spotted is we've just been talking about it. We didn't actually include policy on there at all. So perhaps we could think about that one first. Actually, before I do that, I'll, as I promised, for the benefit of those, if there are any of you who are unfamiliar with the process, I will briefly explain what the various boxes on that table might mean. So no further procedure means we think we have sufficient information already before us to enable us to reach a conclusion on that topic and to report that to ministers. Written submissions means we think we could benefit from further information, and probably the best way we can deal with that would simply be by written submissions from anyone who wants to make them. And generally we would allow a minimum of 14 days for that to come in, quite often more, and then there would be an opportunity for anyone to respond to anyone else's written submissions, and that's usually 14 days subsequently. So that's one procedure for getting to the bottom of an issue that we think we haven't quite got to yet. Then the next column in the table is a hearing session, which is effectively a roundtable discussion chaired by Mr. West and I, and we'll be the ones predominantly asking the questions, although we're not averse to others asking through us questions about other parties, because quite often they'll have a better question than we do, and that is possibly the weakness of a hearing session as opposed to an inquiry session, which I'll come to in a second, where in the absence of an advocate who is well briefed by an expert and who's particularly good at asking questions, there is the possibility that on detailed scientific matters we might not actually get to the crux of a matter. So hearing sessions have tended to be predominantly for differences of opinion that are related to subjective matters, things like design quality and that sort of thing. Recently we've entertained more hearing sessions on more technical information, but typically we tend to prefer, in the interests of getting absolute clarity and finding out so we can report to ministers where the differences lie precisely, we prefer on a scientific matter factual evidence to be tested by inquiry with cross-examination, so we can be sure that everyone's had their opportunity to the full to explain where they're from, and for those opposing view to get to the bottom of where there actually are differences, or where perhaps there might be weaknesses in the other side's case. So those are the different options that we have. So the one we missed off the list entirely was policy, and we were talking about that shortly, and there seemed to be some enthusiasm for dealing with policy by way of further written submissions, so updating anything that has come since, and also perhaps updating thoughts on policy matters. I think I saw, correct me if I'm wrong, Mr. Batten, that you had possibly indicated you might be interested in attending an oral process session, perhaps a hearing on that. I'll come to you in a second, if you have to think about that, because I know Mr. Crabb has his hand up. Did you have a thought on policy, Mr. Crabb?
Yes, sir. I'm grateful. NA-270's primary submission would be that the policy and legal framework would merit an inquiry session. The reason for that is that we have the MP4, which is just a year old, and in our submission, the application of the rules and the framework are central. We've provisionally scoped out an expert who could speak to issues regarding secondary legislation, policy and guidance. If the inquiry is not with me, for the same reasons, my respectful submission, if it's not to be an inquiry, there should still be a hearing on it. So.
Thank you, Mr. Crabb. Mr. Batten. I think you're on mute.
Yes, I'm off now. Hopefully you can hear me. Okay. Sorry, I've got several screens with notes in front of me. Yes, I would like to participate, please, on policy, and I would note that the previous inquiry actually had a heading of policy and relevant statutory guidance, and there are some guidance matters to which I'd be intending to refer. I'm actually normally happiest working with written submissions. In this case, noting that Ms. Coburn, I think, has already suggested written submissions, and Mr. Crabb is now suggesting an inquiry session. My preference is actually going to be for a hearing session for two reasons, well, probably three reasons. Firstly, I would probably struggle with an inquiry session myself. I think that there is a case for oral consideration because there's untested, novel and relevant policy in the development plan, and the inquiry might benefit from there being an interactive form of examination of that, even if expert witnesses were not present. And secondly, coming to my own case, but part of the case I intend to make, which develops my previous submissions, is going to have to be adapted to reflect a document of an official nature and a potential material consideration status, which has been delayed for reasons well beyond my control, and which I have reason to expect at some point over the summer. So I'm concerned that that document may not be available for early written submissions. If you go for written submissions and the document is published subsequently, I would then be minded to request supplementary procedure arising from it. And I note that DPEN Guidance Note 24 has something to say about that. Now, I don't wish to appear evasive, but I'm cautious about saying more about the potential nature of the anticipated document I'm referring to, for fear of straying into evidence beyond the scope of a PEM. So I think you've now got proposals on the table for both written submissions, an inquiry session, and a hearing session. When you, if the conclusion is written submissions, when you come to timescales later in the agenda, I'm going to ask whether the timings of that can be designed in whole or in part to accommodate the document I'm waiting for. And I've got a couple of supplementary comments, but it might be better if you invite others to come in on that first.
Thank you, Mr. Batten. Let's come back to Mr. Crabb, because I know you mentioned, you referred to legislation as well as policy, I think secondary legislation. Is it likely to be NA-270-010-Coul's position that there is some failure to comply with some legislative element that you might want, and that's why you want to bring that out through an inquiry session?
Well, sir, I wouldn't go that. I think I would go back to the point that I make about the novelty of the framework, and of course the framework has to sit within the relevant legislation. So in my respectful submission, these matters kind of need to be looked at together. But certainly, I'm not in a position to advance that argument just now.
Okay. Thank you. Ms. Coburn, did you have a view? I suppose the first question is written adequate, or would some form of oral be necessary, and if so, what sort of procedure?
I appreciate what has been said by my learned friend and by Mr. Batten. However, the RSPB and the Coalition wider position is that matters of policy and legal submissions would be best dealt with by way of simultaneous written submissions, and possibly with the rebuttal submissions, if that would be appropriate. Very much our position that written submissions would be the most efficient and productive way to go about getting that evidence to you, sir.
Thank you. Mr. Bennett, did you have a view on that?
So I don't think an inquiry session would be merited on policy matters, and questionable even whether it would be a hearing. But the council's largely neutral on the subject, and could deal with it either by written submissions or a hearing.
Thank you. Mr. Ferguson, did you have a view or a preference on that?
Written submissions would be the most obvious way to deal with this. I have though been involved in inquiry sessions where a hearing session is reserved following the initial written submissions, so that if any particularly contentious issues remain unresolved, then they can be slotted into a provisional hearing session. So I think either written submissions, hearing session, or the hybrid approach I mentioned, I certainly wouldn't support an inquiry session.
Well, so we would definitely support written submissions. If there is something outstanding at the end of that which you feel requires to be ventilated in any form of oral session, that should be a hearing session. There's no justification for an inquiry session, but our preference at this stage mirrors that of Ms. Coburn's, and that we consider that all those matters can be best dealt with in written submissions with an exchange if necessary, and Mr. Batten could be accommodated by not timetabling those too early.
Thank you. We'll have a think about that. I think at this stage it's quite attractive to me to have the initial, at least, exchange in writing. I like Mr. Ferguson's idea of perhaps scheduling in a day or half a day potentially for a discussion, should we need it, depending on how far apart the parties are, or whether Mr. West and I think we need further discussion just to clarify where precisely you are. Mr. Batten, I know you said you wanted to come back anyway. Have you got a comment on that?
Yes, thank you. That was one of the questions I was actually going to ask, because I checked out the PEM note from the 2019 inquiry, and the reporters then did in fact make provision for a possible hearing session to address matters unresolved through written submissions. It wasn't used as far as I remember, but I think that would be quite a good approach. As a supplementary question to that, my evidence essentially is going to fall into two parts, one of which I think can be dealt with preferably a little later rather than sooner, from my point of view, by written submissions, and it's the second part that may have this evolving situation with a currently missing document involved. So if in that situation a party like me has evidence clearly divided in two and it might assist the inquiry, would you be open to a party making two complementary written submissions under the policy banner, or would you rather have it all rolled into one?
So it depends how late we could leave the policy submissions, the first and possibly only written exchange. If we can leave that, as Mr. Finlay suggested, later rather than sooner, then it might be you can wrap it all up in one. But I don't think we would have any problem if that wasn't possible and you had to come back a second time and say, oh, there's this new document, and then we can have a further exchange on that. But what we need to do is make sure all of that takes place in good time, that if we do have to have a session, people have got time to prepare for that, during the inquiry week, whenever that may be. So we're certainly not averse to doing it in two hits. It'll all depend on the timing, but it won't be, I think, a case where we'll try and get written submissions on policy very soon, immediately, because then that will pretty much necessitate two goes by the sound of it. We can, well, we'll see what the diary is looking like for when the actual inquiry session takes place, but it's not looking like it's going to be immediate. So we'll probably have time to put back all of the written submissions for a while, and you can do it in one hit, hopefully.
That would be very helpful, sir. Thank you very much indeed.
Okay, thank you. Right, landscape and visual effects. We had said we think we have sufficient information before us, obviously subject to us visiting the site as well, which we'll need to do. But I wonder if anyone disagrees and thinks that we might need something else, further evidence of some description. Nope. Okie dokes. Amenity was the next item. It's a very general kind of term, but effectively any matters of amenity that aren't covered by any of the other topics. Again, we thought we had sufficient information on that, unless anyone disagrees. Good. Now, impacts on, well, before I go into we thought, in terms of ecological impacts, which is obviously one of the main issues that we'll need to discuss and advise ministers on, we had thought a way of doing it was to divide the statutory designations into SSSI on the one hand and to the international SPA Ramsar stuff on the other. Whether that makes any sense, I'm not entirely sure. I'm prepared to be told that it doesn't, but that was the plan. I think the logic when we came up with that was, and correct me if I'm wrong, but Nature Scott's interest was confined, or Nature Scott's formal objection anyway, was confined to the SSSI this time around. So in terms of an efficient use of their time, having that separation was attractive to us. But I can also see a logic in having not having that distinction, but having a distinction, for example, a session to look at habitats and a section to look at birds and vertebrates or whatever. We're open to discussion as to which would be the best approach. And as I think we might as well, while we're talking about this, consider both impacts on the SSSI and on the SPA, etc. consider all that together, because I think we'd said no further procedure on the latter, an inquiry session on the former. That, to be honest, that was at a very early stage of procedure, and I know we've reading RSPB in particular's submissions on the SPA. Well, I'll ask Ms. Coburn, but you might not be content with no further procedure on that. I'll go to you first, Ms. Coburn.
I'm obliged, sir. I've just literally put a red pen through the notes sitting in front of me. It would be the Conservation Coalition's strong preference, sir, that the ecological effects are considered as a whole. You'll have appreciated, not to steer into anything controversial, but the boundaries of the three designations for this application are identical. And you have birds that don't consider themselves, oh, I'm an SPA bird, so I'm better than you, you're just a triple SI bird, for example. So it's difficult ecologically to separate it. And I think all that I need to say for the moment is that I would commend the approach that was taken by the reporters at the previous inquiry and suggest that an inquiry session and a focused and targeted inquiry session would be the most efficient and productive way of giving users the best evidence possible to enable you to write your recommendations.
Thank you. Mr. Ferguson, did you have a view on how we deal with ecology?
Yes, Nature Scout's position until now was that your suggested approach was the correct approach. As you explained, it mirrors the now by Nature Scout, which is a triple SI only based objection. However, I was going to make a submission in relation to type of section, and I will come on to that in due course, but coming into this, our suggestion was going to be a hearing section, but we'll park that just for the moment. I think there are three linked issues here. First, there's the grouping of topics together, and Nature Scout is broadly neutral on the grouping. A more important point for Nature Scout is the extent of Nature Scout's involvement, because Nature Scout's strong preference would be to limit its involvement to the mention, so the related issues. And we would be concerned if the grouping issue led to Nature Scout's wider involvement becoming much more extensive than the objection is based on. And the third limit is what type of evidence section would be appropriate for the inquiry section.
In your experience, Mr. Ferguson, I've already veered our hand slightly that we, as reporters, tend to favour inquiry sessions where we're dealing with difficult scientific stuff, because we are lay people. I'm just thinking, in your experience, can you think of a successful hearing session that has dealt with such technical matters?
Going back probably 5 years or more, then our position would be that an inquiry section was the only appropriate section here. But you did mention the evolution of hearing sessions with the opportunity for parties to put questions through the reporter and to receive questions from other parties through the reporter. And it would only be in the context of a hearing session which did involve a healthy degree of back and forth, where, based on assuming that there was a healthy degree of questions, then we think that Nature Scout's case can be fully put through a hearing session, and that other parties would have a fair opportunity to question the Nature Scout team.
Okay, understood. Did you have a view as to what both either written or oral, or in terms of inquiry or hearing, would be the council's preference?
The council doesn't have a strong preference on this. I acknowledge that the reporters may find it more useful to have at least a degree of interaction and questioning by different parties with expert knowledge, as well as the reporters having their own questions. So either a hearing with a degree of questioning by parties through the reporters, or an inquiry, but the council doesn't have a strong view on this.
Thank you. Mr. Finley.
Yes, we, not surprisingly, we do have some stronger views in the council. First of all, we endorse Mr. Ferguson's view that there is sense in not having a combined session, but splitting the sessions. You'll know that we're also concerned about resources and time, and in our submission, the basis of Nature Scott's objection would be different from the RSPB's interests, and there would be sense in splitting the two up, and that would make for a more coherent session. We're also at one with Mr. Ferguson that we'd prefer a hearing session for that session. We think that would make a more manageable session and more focused, and agree with Mr. Ferguson that it should be of the more healthy exchange and back and forth as he suggested. And also there is the more recent approach that quite often draft agendas are distributed with, which allow people to influence the agendas as well. So for all those reasons, we endorse your separation of the topic, and we endorse Mr. Ferguson's approach to have a hearing session on that topic. As to the impacts on the SPA, we've noted what the RSPB have said, but in our submission, we're unaware of any new evidence as such, as opposed to submission that they're intending to bring forward. We note both the council's and the Nature Scott's position. So our submission is that there's no need. We agreed with your view that there's no need. But if the RSPB demonstrate that there's a need, then in our submission there should only be a hearing session. But we remain doubtful at the moment that there needs to be, certainly whether there needs to be any oral session. We're far from convinced. We think that would be unnecessary. But if there is to, obviously not a matter for today, but if the RSPB and all the coalition that Ms. Coburn represents can refer to evidence that may assist you, then that could be a matter for further review. But we're not convinced there is a need for that session at the moment.
Coburn, did you want to come back on that point?
Yes, thank you. Obviously, the coalition's perspective is that there requires to be an inquiry session. This is highly detailed, technical and complex evidence. And obviously the reporters at an inquiry session have the opportunity to raise questions themselves of each witness, to brush up, shall we say, or to clarify any matters of evidence that have not been dealt with by way of cross-examination, evidence in chief and re-examination. I'm not clear whether or not this guidance note is still relevant, but the reporter's guidance note 8 stipulates that an inquiry session might be appropriate where, and I'm quoting now, there is a dispute between parties on complex or technical matters which needs to be tested by cross to enable the reporters to reach clear conclusions. And secondly, where there is a conflict of professional opinion or evidence, the reporter would find it helpful for that evidence to be tested by cross. As I said earlier, this is a technical and complex matter. It is an international designation. It is part and parcel of the reason for the call-in, which is why we were slightly surprised, if I may say so, sir, that you weren't inviting any further procedure. Given that it is up to the reporters to control evidence and the length and duration, then we have confidence that inquiry time will not be wasted. It will be a focused and I hope helpful to the reporters' inquiry session. Coming back to the question about whether or not there should be any oral session at all or any further procedure on the SPA, there is a clear divergence of opinion, sir, between the position of the Conservation Coalition. It's not just RSPB Scotland, it's the position of the Conservation Coalition and the applicant, and in an extent SNH, as was obviously Nature Scott have got a conditioned objection in terms of the SPA, and their evidence and their position must be seen in light of that conditioned objection. So, sir, if I short circuit this somewhat, there is a level of doubt and uncertainty about Nature Scott's position. They provided a response in respect of biodiversity enhancement, and that biodiversity enhancement response came in after the committee reached its decision, but before a decision was communicated in writing, so at that point, prior to any legal decision in planning terms. And what Nature Scott did there was to raise concern and uncertainty about Area 4 that is used by SPA species for feeding. And all I'm going to say, sir, without wishing to get into detailed evidence, is that the position that Nature Scott has adopted in that respect somewhat conflicts and undermines their overall position as one of a conditioned objection. And if I may add, given the timings, it seems that an appropriate assessment didn't include the proposed biodiversity enhancement. So for all of those reasons, sir, my strong preference and that of the Conservation Coalition would be for an inquiry session. Unless I can be of any further assistance, those are my submissions on the matter.
Thank you, Ms. Covenant. That's helpful. Mr. West and I will need to chat through this to decide what we think is the best way forward. Mr. Finlay and then Mr. Crabb afterward. Mr. Finlay first.
So perhaps can I suggest you reverse that order, because I have a feeling I'll be responding to Mr. Crabb as well.
Fine, Mr. Crabb.
Yes, thank you, sir. Not Cool's position, I think we'd essentially adopt what's said by my learned friend, Miss Coburn, in respect to the importance of there being inquiry sessions in regard of impacts both to Loch Fleet, also to the Dornoch Firth SPA, Ramsar and Moray Firth SPA. I'm not going to reiterate the reasons that she gave, but I adopt them. From Not Cool's position, just a few other comments which might assist the chairs. Regarding the land, and Not Cool can provide more information about this. So our submission would also be to include some non-designated land to the south. Those instructed me confirm that there is a particular type of moss which is located there, which is protected under the habitats regulations. If sirs will allow me a moment, I'll see if I can find it. It's a very rare moss. I believe it's called the varnished hook moss. So in my respectful submission, there would be benefit of doing that. Beyond the issue of the SPA, the other issue, sir, just to pick up what you said at the start about ecological impacts and whether this was going to impact on ecology matters such as insects, invertebrate, etc. In my respectful submission, if that is the case, then whatever form the sessions take, the inquiry sessions take, if they're so granted, they should include things such as plants, lichen, fungi, invertebrate, and bryophyrates as well. Given that in the previous report in 2018 there was significant concern about them, and sirs will also be aware of the impact of NPF4 policy 3 in respect to biodiversity.
Thank you, Mr.
We are very concerned, and the last speaker's submissions reinforce that concern about the any session or even written submissions not being focused but being expanded and expanded. So firstly, as far as Nature Scott's position is concerned, we understand, in absent it leaving aside its ground for objection, we understand its position, we think, reasonably clearly, and we understand that conditions are required, and you have a list of conditions that have been proposed. And so we don't think there's any force in that point. In terms of evidence, we're not aware of any new evidence that the RSPB seek to bring that wasn't before the earlier inquiry, and likewise not cool, say for the different type of moss that's just been mentioned. In our submission, before you institute a oral session on this, there must be some proper basis for it. You'll be aware of the limitations on the applicant's resources, and before any form of, certainly before any inquiry session is required, we consider that you should be sure that those are thoroughly justified before ordering them. So in our submission, we reinforce the need to keep the suggested sessions separate, and we remain wholly unconvinced of the need for anything more than at this stage written submissions on the SPA matters.
Okay, thank you. Mr. Ferguson.
Yes, sir. I'm not sure if now is the appropriate time to raise this, but we did have some queries and clarifications in relation to the bullet points for the individual topics which you had earmarked for consideration under the SSI section in isolation. If you want me to comment on those now, or as this discussion evolves.
Yeah, it's slightly been overtaken by events. I mean, I'll let, as I say, Mr. West and I need to talk about how we deal with this. I am, and I'm looking at Mr. West. I'm leaning towards more oral process than written. Certainly, we need to have some form of discussion, I think, on the European SPA Ramsar issue. And while I am conscious of constraints on both the applicant and on Nature Scotland, we all want to be as efficient as possible. I'm somewhat attracted towards dealing with ecology and all of those effects in some sort of session, albeit trying to subdivide such a session so that witnesses, because they are also specialised, somebody's a bird person and somebody's a fly person, don't have to sit throughout the whole session. So some sort of composite session, but which not all witnesses obviously need to be there for the entire duration. But Mr. Weston and I need to think about this. And Ms. Coburn is certainly right that Guidance Note 8 does still apply. That is our guidance, which suggests that technical matters tend to be dealt with by inquiry. But Mr. Ferguson is also correct that latterly we have evolved. Mr. West is quite a pioneer on this of engaging in a session where, because we don't necessarily have the best questions, others are able, including legal representation, not in the form of a detailed cross-examination, but just offering a helpful contribution to the discussion. So in that way, a hearing session, or a sort of super hearing session, as we tend to do now, can be more effective than perhaps hearing sessions of old, which certainly I think weren't suitable. If you're relying just on our questioning, weren't suitable for getting to the bottom of detailed technical evidence. But Mr. West and I need to talk about whether this might in fact still be a step too far for that sort of hybrid super hearing type approach, and whether we do need to have full-on cross-examination. So it's all up in the air. So going back to you, I'm happy to hear your thoughts, Mr. Ferguson, now about those bullet points, but I suspect they may, to some extent, have been massively overtaken by events, given that if we do go towards a more sort of a combined session, albeit with some subdivision, then but I'd like to hear what you say now, because that can all go into the mix while we think about what we're going to do.
Yes, there's reference to characteristics, qualities, mapping of features. The overall Nature Scotland points are whether the session, as originally conceived, was intended to focus on the sand dune features only. There are a number of other notified features from Nature Scotland's perspective that's not relevant to Nature Scotland's objection. It was really a question in relation to habitats and species.
Yeah, sure. Yeah, I think the discussion, we certainly need to advise ministers on more than just the habitats. And I know there's a detailed technical argument about proportions that are lost and all sorts of other issues of dispute, but there are all other issues of concern to local people, not necessarily just about habitat loss, but about individual species effects on, and also, as Mr. Crabbe says, out with the SSSI as well, potentially. So I think that the evidence we will need to advise ministers on is certainly broader than that. The question is whether we think we have enough information on the other things to deal with that without oral session. Certainly the issues, the technical discussion about what constitutes loss of a particular habitat and what is not loss, and what proportion of the site is to be lost. You know, all of those that we definitely do need some sort of oral session on, which I think was the main thrust of Nature Scott's objection. But there are other, you're right, there are other features of the SSSI that will also be affected. The question for us will be whether we've got enough information thus far to avoid that being discussed orally. And I'm conscious if those are not points that your client is wishing to make, then you have no interest in that being included. And similarly, Mr. Finlay, but others may. I think it was Cohen's point that birds and things don't know if they're a SSSI or an SPA bird, or or they're not in either designated area. There may be species that require to be discussed, but I don't want to close down the discussion within that session too tightly, but at the same time, I don't want it to be a monster session that involves an entire week of evidence and lots of witnesses sitting around waiting for their turn to go on, and it being a difficult. So I'm not being very helpful here, but and it'll become even more apparent when we try and think about time slots if we haven't actually got to the bottom of what format this is going to be taking. But just thinking aloud, Mr. West, you can shout if you disagree. Thinking aloud, I'm thinking of some sort of composite oral session to cover ecology generally, but with finely delineated subtopic areas within that, so that people hopefully don't have to have witnesses appearing and sitting around when there's no chance of them being involved in the discussion. And I'm leaning towards trying to do that by super hearing session, but we need to get to the bottom of how complex this is as to whether that's actually going to be possible. But as I say, the hearing session can involve quite detailed exchanges of view and questioning, as long as it's done in the spirit of cooperation, etc. It has worked recently quite successfully doing it that way, and it definitely saves time compared to a full-blown inquiry session, because there isn't the repetition. And as I say, lawyers are very, very welcome to take part in that. And in some respects, I think those participating find it easier as well. Not that that should necessarily be a overriding factor, but it's certainly relevant. It's a public inquiry. We want everyone to be able to participate. So I'm rambling now and not probably helping massively at all. But when we get on to the next session, we're talking about allocating some time and how long this is likely to take. I think it's safe to say that I'm leaning towards a big-ish session of some description dealing with all ecology matters, but going into more detail in some. I mean, as Mr. Ferguson, I think, said, we will be issuing a detailed agenda in advance, so it'll be clear to the parties this is where we think we've got a gap in our knowledge. We'll be covering this topic area, and we'll be asking the following questions, and you can then arrange your own questions around things that we have missed or subtleties that we haven't picked up on, etc. I will quit rambling. Ms. Coburn, you had your hand up. You still need to say something.
Yes, sir, I did. Thank you. It was just really to come back on the point of resources, because clearly resources is not an issue that's confined to the applicant, Nature Scott, or everybody else. It would be helpful, sir, if when you consider the topics that are to be dealt with orally, if parties who are not giving evidence on a particular topic might be excused from that particular session. Yes. Certainly that's something that the Conservation Coalition would be interested in, and I know from previous experience that such as Nature Scott are often missing from large swathes of inquiry sessions, which doesn't affect their interests. So if I could make a plea for the topics to be chunked so that we might be able to stagger availability and participation, I'd be very grateful.
Absolutely, yeah. I think everyone would want that. Yeah, we'll try and
Thank you.
that's a challenge for us. We'll try and do that. Anyone want to say anything else about logical matters in general before we move on? I'm sorry, it's very up in the air. We haven't really got to the bottom of it massively, but I'm kind of clear in my own mind we're going to need several days, hopefully, at which not everyone has to attend the whole thing. But we're going to need several days, I think, of some form of oral process to talk about ecology. This is obviously one of the reasons why ministers called the application in. So it is a big issue that we need to advise them on. No hands are up. So if we move on, I think the next one was vehicular access and parking. I don't think that was a massively show-stopping issue for anybody. Nobody's got their hand up, so I think we've got enough information on that. Tourism and other socioeconomic effects, obviously that is a big issue. That's the counterbalance to the ecological questions. And we were proposing this. Well, at first we think it needs an oral session just to get to the bottom of the benefits, and anyone who disagrees with those benefits. We thought that was quite capable of being handled by hearing session, but you know, if anyone wants to tell us otherwise, I'll start with Mr. Finlay, I think, if you don't mind. Does the applicant have a view on that?
We're broadly content with a hearing session, provided, well, it depends how many people want to take part in it, but we're broadly content with a hearing session on that.
Thank you. As I said earlier, it may be that some of the local supporters would actually prefer to go to just an informal evening session to tell us about their experience of the local economy and what benefit they think would derive from this, and those of the opposite view, obviously, as well, rather than turn up to a technical session where we're talking about socioeconomic benefits in, you know, more scientifically, if you like. So we may, obviously, I'll leave that with those who are organising things, but it may not necessarily need to be a cast of thousands who are coming all to tell us the same thing during the hearing session. Ms. Crabb, you had your hand up.
Yes, thank you, sir. NA-270-010-Coul's proposal would be for an inquiry session. The reason for that, sir, is that we've instructed an economic expert, that's Professor John Lennon of Glasgow Caledonian University. As sir's already mentioned, the matter about the significance, whether national or otherwise, of the proposed development is a key part of the call, and we're likely to have two skilled witnesses who are likely to have competing versions of events, and under normal practice I would submit that would be tested by cross-examination. As far as I'm aware, there's no other party seeking to challenge the economic case apart from NA-270. So if there was to be an inquiry session, my submission that we wouldn't be talking about days and days like sir's concerns about the ecology matters.
No, understood. Right, I've got no news, and I've forgotten. Apologies, I've forgotten your name terribly. I've got Mr. West will advise me as he's taking notes, possibly.
I have my hand up. I don't
That's
know.
You, sir. Yes, I've forgotten your name. Apologies.
Jerry Bishop, former community councillor. Just maybe as a matter of information, Donach has since, within the last year, voted for a business improvement district, and we're now represented by a bid group. And it may well be that some oral evidence on tourism and the effects of local tourism might be beneficial. I'm thinking that if we've got people from the Central Belt coming up as expert witnesses on tourism, that might be conflicting with a local view. And I think that the Community Council, who have previously submitted to the public inquiry, probably would want to have their voice heard as well. I have to say that I will be reporting back to the current Community Council, and I suspect that they will want to discuss their options and take a view themselves. But I'm really feeding this back as information. Thank you.
Thank you. Mr. Bennett, did the council have any preference as to how this would be considered?
Again, we don't have a strong view, sir, but I would have thought that this would be capable of being dealt with by a hearing session and possibly only a single day if there are only two parties really involved in it. And it might make sense to have it close to any evening session that's likely to have an overlap, either the same day or the day after.
Thank you. Yeah, I don't think anyone else is planning to. Oh, I've got another hand up. No, I think that's gone already. It's Finley.
Yeah, just to say that we endorse Mr. Burnett's approach that that there's no basis for at the moment for having anything other than a hearing session, and that NA-270-010-Coul may be instructing a witness in the future to provide some evidence. Presumably, they don't know what he or she is going to say yet. In our submission, there's no basis for a lengthy session. The matters upon which the Scottish ministers have called it in clearly include this, but that doesn't of itself justify the need for an inquiry session. Just like the first session, I believe, was not called in for basis of impact on birds, but the basis of impact on vegetation, and that should influence your thinking as to the extent of the sessions you have or not.
Thank you. There's no more hands. Yeah, I think I'm certainly minded to have a hearing session on this, and I think, but again, with the proviso that it be those who are expert will be able to ask questions to us of each other. I don't want Mr. Crabbe's witnesses to feel that they're constrained in any way. I think it's likely that we could simply deal with this in one day and have a really good go at it via a hearing session. And that if it were to be an inquiry session, I think inevitably it's going to spill over longer in terms of timing, and probably not give us any more than a really good hearing session would give us. I think it's not so out of our comfort zone, to be frank, that we couldn't really feel we've got to the bottom of the evidence in a really good hearing session for a day. So, and again, as I say, lawyers are very welcome. I know Mr. Campbell is very well versed in participating as a kind of non-lawyer, but a very helpful participant in these hearing sessions. So he'll advise you on how much he likes them, I'm sure. But it can work. For something that isn't mega technical, I think it can work, and I think this falls into that category. So if we can try and park that in our mind when we're thinking about how much time we might need. Moving on, cultural heritage, including archaeology. Mr. Batten. You're on mute.
I'm hopefully off mute now. I've been sitting quietly listening to that very interesting conversation on both the ecology and the economic side of things. I'm conscious that those are the opposite sides of the coin, which appears a number of times in NPF Policy 4. I'm very much in the position of supporting anybody who's arguing for an inquiry session on either of those sides of the coin, and quite possibly both, in which I wouldn't personally participate. If you're looking at a hearing session, or possibly a super hearing session on the ecology side, then I might actually consider participating in a very minor way in that. I would have thought it would be a very brief hearing statement, but just to I'm noticing one or two people in the chat of the meeting trying to introduce a lay perspective, and I would certainly consider doing that in hearing sessions on either ecology or possibly on socio-economics, if that's the conclusion that you come to. Thank you.
Thank you, Mr. Batten. Yeah, I mean, there is an advantage of a hearing session is that, provided that all participants get their points that they want or may want to make, as long as they get them in advance, so it's fair to all parties, they can simply take a position around the table and, if they wish, contribute in accordance with what they've previously notified us or not. So rather than having to wait their turn and then be cross-examined, etc., and that is perhaps more off-putting. They can, if you like, reserve the right to participate, but if it turns out others are dealing with the matter thoroughly, then they can choose not to and simply just sit and listen to the conversation. And the other, as I said, the other possible mechanism by which people can get involved, if even that is perhaps a bit more daunting than they would like, would be an evening session. We'll talk about that in a second, where it's very much less formal and it's in the evening, so perhaps less of a constraint to those who have jobs to do during the day. I don't think there's any more hands up. I was going to turn to cultural heritage, which I don't think is a matter we need any more information on, unless anyone tells me otherwise. No. Conditions. A short hearing session, it's usually half a day. Sometimes it's not even that. What I've tended to do lately is pencil that in, but in the hope that parties that can get agreement before then we may not actually need it. So we'll see how we go. And the last inquiry I did, it was nice. We could actually end half a day early because we didn't need it. So it's an incentive maybe to not need it. But does anyone disagree with at least penciling in a hearing session to talk about conditions? No. Good. Hopefully, you don't need it. Coastal impacts. I think this was so. Other than the stuff we've talked about, I think this was specifically talking about sort of climate change, erosion type of thing. Other than what might also already be considered, probably in discussion about the habitats in the SSI. So, perhaps I suppose I don't know. We're saying we think we've got enough information, so I suppose this is coastal impacts, other than a discussion about ecology and stuff like that. So the implications of coastal erosion, etc. Mr. Crabb, I'm floundering. Maybe you can help me as to what that might involve.
Yes. So be aware that there was an inquiry session on this last time. NA-270 submission is that matters have moved on, and clearly climate change and associated matters are not static. They continue. Part of the concern that NA-270 has is that in respect to the planned area for the golf course, that some areas have fallen or are close to falling due to recent erosion. So in my respectful submission, there is a new matter at play there, and it's also a new matter that's tied in with again going back to MPF4, policy 10, which deals with a specific issue. So in my respectful submission, some kind of a session should be available. Our primary submission would be again for inquiry. We have an expert instructed, Professor Hansen, who gave evidence last time, and I believe the applicant has Dr. Pyle, I think it is, who again was instructed last time. So again, we may well be looking at evidence of a technical nature, which should be explored by way of either a hearing or an inquiry session.
Thank you, Mr. Finlay.
Our view is that your initial view is correct. You'll be aware of condition 19, and that which makes provision that there are to be no coastal protection works, and that the risk of erosion would fall on the applicant. And in our submission, there's absolutely no basis in need for further material. Certainly not on the evidence that's before you at the moment, and very far from the need for an inquiry session. But in our submission, on the basis of the approach being taken by the council, which is accepted by the applicant, along the lines of what is currently proposed as condition 19, there's no need for any further approach on this issue. And bearing in mind the finding of previous reporters, you should have all the information you need on this point.
Thank you.
It would be quite different if we were proposing some form of coastal protection works, then that might be an issue.
And it's still your position, Mr. Finlay, that your client accepts the risk that if they lose a couple of holes, then there's no guarantee they can move them, putting it crudely.
Absolutely, and that's the purpose of condition 19.
Right. Thank you. Mr. Batten.
Yes, thank you. I'm grateful to Mr. Finley for mentioning condition 19. And actually, that would be one of the reasons that I'd be seeking to participate in the conditions session, if there is one. I'm not sure, with due respect, that I concur with his reading of that condition. And on that basis, I'd be very much supportive of NA-270-010-Coul's position that there should be oral evidence on this topic and quite possibly an inquiry session, though I'm not personally in a position to say any more apart from the fact that the tide seems to be rising. Thank you.
Thank you. Okay, yeah, I'm certainly leaning towards not having further procedure on this, on the basis that the condition to which Mr. Finley refers would effectively remove the possibility that in the event of erosion, which I don't think anyone claims is not a risk, that in that event of that happening, there would be some automatic right to cause other effects by virtue of moving holes and things. So, but Mr. Batten is correct. We need to make sure that the condition does what it says. So, but that would be in the form of the condition session rather than a dedicated session to talk about the technical aspects of erosion. So,
we have a hand there from as well.
Ms. Wilson, sorry.
Yes, I'm sorry. As a lay person, I'm following all this as best I can. But can I just get a bit more of an explanation about this condition 19? Do I understand that if holes disappear because of erosion, the golf club will have the right to open up holes in other areas of land, so it's still an 18-hole golf course?
Mr. Finley?
No, it wouldn't have the right to do that. And the condition says, just in case Mr. Batten's concerned, for the avoidance of doubt, CRP shall ensure that the coastal links shall remain free from future coastal defences proposed to protect golf course assets. It couldn't be clearer. If there was to be, there would need to be a further application for planning permission if a hole did disappear and a new hole was proposed. So that is why both the reporter and I were referring to risk. The risk on that would fall with the applicant.
Thank you for clarifying that. I appreciate it.
Thank you. Mr. Batten first, then Mr. Burnett.
Right, thank you. So it wasn't the bit about in condition 19 about the absence of hard engineering that I was querying. It was the business about provision for moving holes, and I don't actually have condition 19 in front of me, but my recollection was that the condition, as it's worded, actually provided for potentially moving holes in future without a further planning application. That would start to overlap potentially with the question of hydrology, which you haven't come to yet. But I'm still very much of the view, in support of NA-270-010-Coul, that it is essential to have some further procedure on coastal erosion, and that if you don't have that, then I don't think, with respect, you're going to be in a position to advise Scottish ministers in respect of policy 10.
Before I come to Mr. Burnett, would you, because I think you were indicating previously, would you be content that if changes were made to condition 19 that secured what you think needs to be secured to prevent anything just going ahead without the proper procedures, a further application for a modified layout to the council or whatever, would you be content, or would you accept that that would be a mechanism, if you were happy that that condition would work, that would be a mechanism of guarding against untoward consequences as a result of erosion? Effectively, the applicant would be stuck unless they could prove to the council that removing the holes would not cause the problems that you're concerned with. If the answer to that is yes, then I think I'm minded to have this discussion in the conditions session to make sure that in the event that ministers were minded to grant permission, they had a super condition that really did the job and didn't leave any doors open that could cause things like hydrological issues. Does that make sense? Rather than opening up a scientific debate on the effects of climate change, which I think everyone's agreeing is a legitimate factor, but rather than opening up a long discussion about that, where ultimately the parties may actually agree that there could be a possibility of erosion. Does that make sense?
Well, I can see the attraction of perhaps firming up on the situation being at the applicant's risk, but I would draw your attention to the very specific conditions in policy 10B, which is wholly new policy in NPF 4, which seems to have been the subject of very little consideration by the statutory consultees or the council. It has been raised in my submissions hitherto, certainly in NA-270-010-Coul's, and to some extent in the conservation coalitions. And I'm struggling to see how you can evaluate the application against the specific tests of policy 10B without all evidence.
Okay. Mr. Knight.
So I was just going to endorse the proposed procedure of having this matter discussed during the planning conditions session rather than a separate hearing or inquiry session. I think it's already clear from much of the discussion we've just had that the real question falls in the terms of the conditions. So I think the council would favour just this being put into the conditions session.
Thank you. On the question of compliance with policy, we've obviously agreed that there will be a session on policy. I'm just wondering if we could deal with, or there may be a session on policy. We'll deal with it in written submissions initially, but I'm wondering if that is the answer to compliance or not with policy 10, coastal development. Rather than having a technical discussion, we've already got some technical information before us and differences of opinion and the like. Yes, you're right, Mr. Batten. We need to make sure that we can advise ministers as to whether it complies with that important part of the development plan. But my initial thought, I will, before issuing the agenda, Mr. Weston, I will discuss this matter. But my initial inclination is towards addressing this through the submissions on policy and possibly a policy session and on the discussion of a watertight condition, rather than reopening up to oral debate the whole question about erosion, etc. Not to diminish the importance of that, but just bearing in mind if the consequences of it are not a knock-on effect that might be undesirable, then I'm not necessarily convinced, but I will have a thorough read of policy 10. I'm trying not to read it now as we're talking. I'll frame my discussion with Mr. West in that, with that in mind. So I think if in terms of timetabling, which we'll come to in a bit, I'm going to park this as being, we don't need a session, an oral session on coastal impacts, a specific. It will be touched on, I'm sure, in the ecology session, but we don't need a separate session on sort of coastal recession or whatever, unless I come to a concrete conclusion subsequently. But in terms of timetable, I think I'm concerned we'll just leave that as is at the moment with no further, no further procedure. No further hands up. Can we deal with public access and recreation? Because I know that's another issue of interest, certainly to local people in particular. We thought we had sufficient information to date, coupled obviously with the site inspection, so we can work out where the core path goes, etc. Did anyone disagree with that view? Good. Water and drainage, hydrology, etc. Mr. Batten, I know you touched on that, but again, we felt we had sufficient information on that to know where we are. Mr. Crabb, I'll ask you first. You've got your hand up.
Yes, thank you, sir. In NA-270 submission, there would be benefit in a session of some kind, either hearing or inquiry. Clearly, it's a matter of whether the site is sustainable as a site for, and nature depends on the rising and falling of the water table. And if Sir, as regards to the conclusions in Chapter 4 of the report in 2019, there is some dubiety about the impact of matters relating to water abstraction, and that's a matter that could be it could be clarified. I think again both the applicant and NA-270 have experts instructed in that, so that's a matter that could be dealt with, and it could, in my submission, it could assist the reporters in coming to the recommendations.
Thank you, Mr. Finlay.
So again, there's nothing that NA-270 have raised that justifies any form of further procedure. My understanding is that Council was satisfied with this issue the statutory bodies were, and there's no basis on having a session at this stage that which we're aware that would assist you in writing your report to the ministers.
Thank you. Governor?
Yeah, thank you, sir. To an extent, we support NA-270's position, in as much as the effects on the hydrology, I think, might usefully be considered as part of the wider ecology section. Certainly, I fundamentally disagree with Mr. Finlay's point in that regard should be taken only of the statutory consultees and the Council's position. The reporters very clearly took a different view and clearly expressed that, criticising the applicant for their failure to work with RSPB Scotland in relation to words. So I would just like to put a marker down that fundamentally disagree with any assertion that no further procedure is required, if this is what Mr. Finlay is suggesting, that no further procedure is required if that is the position that is adopted by the statutory consultees and planning authority.
Okay. Yeah, I had anticipated that those hydrological effects that would have nature ecology implications would be dealt with, as you say, Ms. Cohen, in that mega ecology session, and that any other effects would be able to be dealt with based on the material we've already got. I will, though, Mr. Crabb, I will have a look at Chapter 4 of the previous report just to make sure. I have read it, I'm sure, but I'll make sure that I'm clear in my mind that that remains the case. But at this stage, I'm certainly content that the only water and drainage issues about which I'm not 100% sure are those with nature implications, which we would be dealing with anyway in the ecology session. So that, as I say, I will look at that. But as it stands at the moment, in terms of time programming, I think I'm minded not to seek further submissions on that. Which just leaves the evening session, which I've been referring to throughout. A couple of hours usually, one of the evenings. Perhaps, as Mr. Burnett said, we can time it so it fits in after the socioeconomic discussion, so that those who want to participate on a more informal basis and tell us about their local experience can do that on an evening. I saw a hand up there, and sorry, it's vanished again. Yes, Councillor McGilvray, I think.
That's indeed right, Mr. Brewer. In terms of venue, can I ask that some consideration be given to the Amble Community Centre as a venue for any kind of in-person interviews that are taking place? It's much needed revenue for the community centre, which is struggling at the moment, and also will do many of the participants here the word of good to be able to come to Amble and see the place on the ground.
Yes, thank you. Yeah, we will come to the venue, but yes, in these days of virtual meetings, which I am not an expert, as you can tell, I struggle with these a little bit. We are still, especially where it's a session or it's a topic of very great local importance, we tend still to want to come to the venue and have a session in person. albeit for those who are further afield, this has worked quite well recently. We are happy to have a hybrid session, so that those who aren't able to be present can dial in, and we found even in an inquiry session that's actually worked fine. You know, cross-examination through a television seems to work fine, but and certainly in a hearing session, it seems to work perfectly well. Even overseas participants have managed to make it work. So thank you for that suggestion of a venue. We're always very keen on a sort of community venue in preference to one that's privately owned. Also take any other recommendations of suitable venues when or nearer to the time coming. I'm just checking I haven't missed anything on that. Oh yeah, so any well, I'll come to Mr. Crabb first. You had your hand up, I think.
Yes, thank you, sir. Just a clarification in terms of what local people mean. Is that going to be assessed in terms of relevancy or a geographical distance? I think, sir, just to clarify, I think sir mentioned before that people would submit a statement or some kind of written information before, and also presumably that would be local people who are either for or against the development.
Yeah, absolutely. Anyone who maybe doesn't feel they want to participate in one of the more formal technical sessions wherever they live is very welcome to turn up on the night. But to avoid it becoming completely unmanageable, we like people to register their intention to speak in advance and to provide a sheet of paper or whatever that will set out what they're going to say. Usually they'll simply read that out. And it will be for those who are in support or opposed, and not necessarily those people who are local. You know, anyone's welcome to attend, and subject to the technology working, which, as I say, generally does work fine. They can dial in, and we can watch them on the screen if they're not able to be in person. People seem to get quite a lot out of it, and it's useful for us to be able to hear, you know, the genuine experience of members of the public who wouldn't necessarily otherwise feel comfortable about participating. Train of thought slightly. So yeah, I don't think anyone's objecting to there being an evening session at some point. No, good.
We have a hand.
We have a hand. Thank you, Mr. West.
It's a physical hand. You're on mute. So.
Oh yes. You're still on mute.
Sorry, my apologies.
Okay.
Can you hear me now?
Yes.
Sorry, just one quick thing. I understand your reasoning for suggesting to open up an evening session to everyone. I think that there is a lot of kind of concern within the local community about the interference and the comments from outside. I mean, we were aware last time that there was a massive petition arranged by some members of the coalition, Conservation Coalition, and I think there is a fear or a feeling that the local voice does tend to get lost a little, and people might be more persuaded to come and tell their story if it was a local session only, rather than having to I'm struggling to phrase this correctly, but maybe run the gauntlet of an organized opposition. I'll say no more. I just would ask you to consider that in your deliberations. Thank you.
Thank you, Mr. Batten.
Yes, thank you. I think I'm going to have slightly disagreed with Mr. Bishop, I believe it was, on this. We are talking about national and international assets here, and I think it would be very unfortunate if a public opinion section were restricted only to local people. And to start with, you have to decide what's local. Am I local? I'm 30 miles away. Where do you draw the line?
If I could just rebut that, I'm not suggesting that it's that people from outside the area are excluded. I'm just saying that I think it would be of benefit, and you would get an impression of local opinion if there was a specific session for people particularly residing in the IV25 locality who are most immediately affected by the proposal. So just to clarify, I'm not suggesting that people are not included. I'm suggesting that there is some attention given to the local view, and by local, as a former community council, I'm very clear about what is local. Thank you.
Thank you. Mr. Finlay.
Yes, I hear what Mr. Batten says, but the purpose of the session, as I understand it, and these sessions, is to allow people who are directly affected one way or the other to have a local voice. And I echo the concern that if it goes beyond matters of concern to the local community, then it ceases to be of benefit and may cease to be attractive. Persons such as Mr. Batten have had clearly have their opportunity to have their input, but we're very happy to leave it to your judgment as to local community and common sense. But in our submission, we're not positively pushing for an evening hearing session, but we can understand why one may be appropriate because of our representation that we pointed out to you already. But we would be concerned whether if it was to be broadened beyond the local community.
Yeah. Mr. Batten, did you want to come back, or is that a residual hand?
Yeah, it was my hand indeed. Just to clarify, I have absolutely no objection to a session which is restricted to IV25 participation, and certainly it's my intention, as you know, to participate in other ways. But I would just come back to my comments about these big national and international assets, and I think that if you only had further low-key participation restricted to IV25 people, and no further procedure opportunity on a small scale for some of the other people from far and wide who are connected to the meeting this morning, some of whom we've heard from, then I think that might be a little bit unbalanced. Thank you. I'll rest it there.
Thank you. Dr. Starkey.
Could I just raise one particular point about local and community councils? If you look at the Highland Council map, which delimits the territories for Golspie Community Council and the Dornoch Community Council, you will find that Cool Links is split in two by the two. And I would like local to actually include people from Golspie and possibly even people from Tain, who are literally just a 10-minute drive over the Dornoch Bridge. Thank you.
Thank you. I think for now, anyway, how I would propose we deal with this is we have an evening session open to all, and with the requirement that those who want to come have to tell us in advance. And if it appears that we're getting an unwieldy number of attendees, perhaps we consider a subdivision and have two evening sessions, and perhaps in doing so we divide up those who are local and those who are less local, or some subdivision that might ensure that everyone's happy that they can come and speak. But I suspect that's unlikely. Where we've had these before, those who actually, in my experience, those who actually turn up on or want to turn up on the night are genuinely local people, rather than those who are from further afield. And certainly I can't recall a case, even which has been quite controversial, of anyone who was not at all local and was opposing something that the locals were supporting who actually turned up at one of these events. It simply hasn't happened, let alone to the extent that it might be intimidating or something for local people. So I think we'll just slot it in as an evening session for all who wish to participate, and we'll see where we get from there. But if we get 100 people wanting to come, then we'll have an issue to deal with, and we'll see how we deal with that. Dr. Starkey, we want to come back on that. What was your hand? Just
Sorry, I'll remove my hand, sir.
Thank you. That's usually my favourite trick of leaving my hand up. I think that's everything. So an evening session of some description, or possibly two, but hopefully not. Right, so point 6 and 7 possibly are more, or can be intertwined in terms of who wants to come to each session and when are they going to be. Because I'm not taking my own notes. I'm looking at Mr. West to remind me what we've agreed.
We've agreed initially that we'll need potentially a half day for policy.
Yeah. So we need to pencil that in, certainly.
And we've got what I've taken from the discussions as potentially needing 3 days for ecology, or up to 3 days. 1 day for tourism and socioeconomics, half a day for conditions, an evening session, maybe 2.
Thank you. That's very helpful. So policy, well, it was policy half a day. Do we think that's sufficient, or maybe a day? Hearing session if we need it. I know we said we would try and resolve it by written subs first, but do you think allowing half a day is sufficient, or do we? But it depends whether we can try and, if we're aiming to get it all within 1 week, if that's even remotely possible. Mr. Finley.
Well, certainly say on behalf of the applicant, we'd be very keen for it to be dealt with in a week. I fixed on 3 days in my mind, like Mr. West, for the combined session, and whichever way the cake is cut, I would have thought that the conditions, tourism and socio-economic, wouldn't necessarily need a full day, and policy won't necessarily need a full day, that those 3 matters could be dealt with in the remaining 2 days. I would hope that if there is indeed a focused approach to ecological matters, that might not take the full 3 days, but it would certainly be a matter of significant and serious concern to the applicants were the inquiry to extend beyond the week.
Okay. Ms. Coburn, on the basis that we're doing some sort of super hearing, I think I've invented a new term now, but on the basis that we're doing having a really good go at a hearing session rather than a formal inquiry, and I said I'm still going to think about it, but that's the way I'm leaning. 3 days sufficient, do you think, for the ecology matters?
I think I might be the voice of doom and gloom in the corner, sir, on the basis that I think it could be done quicker than how it was done last time. But I think last time was 2 weeks purely for ecology. So my hope is that the entire oral session could be done and dusted within a week. How ecology would fit within that, whether as an inquiry or a hearing, is a matter for you. I wonder if it might be helpful to raise this point now. With a super hearing, is it intended that such as hearing statements and precognitions would be required, or simply hearing statements?
Yeah, no, where I've done them before, it's simply been hearing statement and and obviously documents, and in those documents may well be some sort of paper, like you would have in as a supplementary
like an inquiry report, sir.
Yeah, as a way around the 2,000 word precognition limit. It's actually very helpful because it comes out earlier with the document, so everyone's got a chance to read it. And I was thinking a short hearing statement, just saying, this is the outline of what we want to talk about. These are the people who will be coming to participate. And as I say, even if it's a hearing, we will have subdivided it into subsections of, we're going to talk about birds first and then about whatever. So hopefully that could be fairly brief. And then after the document submission stage would be when people would put in any extra papers, if any, that they wanted to rely on. So there wouldn't be any formal recognition or anything, and then it would essentially just be we would be leading the discussion with questions that we'd worked very hard on, but there'll be lots of other questions that come and flow, and I mean, if it were done by that procedure, I think 3 days is quite a long time. You can get a lot of ground covered. You know, it's amazing what you can get done in a day doing that. Certainly, if it were to be an inquiry, then I think no real chance, depending on how many witnesses, obviously. But I think because it's subdivided into so many specialists, it might be difficult to get it in 3 days. But I mean, we want at the end of the day, selfishly, to get to the bottom of everything, so we're absolutely content we could advise ministers properly. So that's our primary consideration. But we're not blind to the issue of cost for all participants. You know, if we can keep it within a week, that'll be good for us as well. But ultimately, we want to make sure we get to the bottom of everything. So,
there could be the option that we set aside a week and prioritise ecology, and then if we overrun beyond those 3 days, there could be the potential for virtual sessions to pick up those matters which you don't need the witnesses present for.
Yeah.
And we could still do the evening sessions at that stage, so we could have some flexibility.
Yeah, so maybe an overrun in, if we had to, into week 2, but on the basis that it would be virtual, so it's less difficult for people to participate. As I say, it's important that we are there in the area so that local people can get involved. But the evening sessions, as you say, would be ring fenced to that. They would definitely take place, as would the discussion. I think I would want to have the technical discussion, if at all possible, on socioeconomic stuff in person as well, because a lot of the people will be local on that, I suspect, albeit with some experts. But definitely, I think what matters most to me anyway is to get the ecology stuff dealt with within that week and at the venue, because when we do our site inspection, it's quite likely that technical people will want to point us to particular things as we're wandering around the site, and this is what I was talking about before, or perhaps we'll do it before, I don't know. But so we're looking at, does anyone disagree we can try and get this done within the week with a possible overrun onto virtual? Mr. Batten?
I'm not disagreeing with the proposition of a week plus overrun, but you posed the question of whether policy was going to fit in half a day, or might be nearer a day. Mr. Finley, I know, had a view on that one, and what I've heard this morning, and it's been very helpful, thank you, is that you're going to try to do policy by written submissions in the first place, and then see if you need to pick out any specifics from that need some form of oral session. But what I also heard was that if you're going to have no further procedure on coastal erosion, then the business about policy 10, you were looking to take that within the policy session. Now, not cool, I understand, have a witness whom they might want to introduce into that policy session, and I wouldn't be entirely surprised if some parties were interested in including matters about that in the site inspection. So yeah. My suspicion is that it might be prudent to allow a day for oral evidence on policy, although hopefully you might be able to fit something, possibly including conditions, into that day.
Okay, I mean, I think conditions would be the one that gets the boot into week 2 as a virtual session, if we even need it. That would be my preference. But yeah, I hadn't thought about the issue of policy 10 and hydrological things, and the fact that we might want to look at something in particular on site. So that does tend to push it towards being hopefully considered within that week. But I think if our aim was to kick off with ecology first and get that out of the way in hopefully 3 days, maybe even less, and then go on to, if we need to have oral policy discussion, and well, in fact, probably logically, policy tends to come towards the end because we can discuss policy compliance in the light of what might have already been talked about in terms of technical effects. But yeah, certainly I would like to have socioeconomic and, if we need it, the policy discussion within that week. if it is at all possible. We will know before the week kicks off if we are going to be talking about, well, if we are going to have a policy session, and if we're going to be talking about hydrological and policy 10 issues. And if that is the case, then NA-270-010-Coul's person may want to make themselves available for the site inspection, even if we don't get around, unfortunately, to having the discussion during that week. I don't want to put them to any inconvenience. I certainly don't want them to have to travel twice. But who's first? Ms. Coburn, I think you had your hand up first, and then Mr. Crabb.
Thank you, sir. I wondered if it might be helpful in terms of cutting down possibly the time at an oral session if the applicant would be prepared to draft a statement of agreed matters, and that might help to focus the issues in dispute. And there was one other point that I was going to ask as well, which I've completely forgotten about. I'll stick my hand up again, sir, if it comes back to me. Forgive me, it's an age thing these days.
Thank you. I'll come back to you in a minute, Mr. Finlay, about statements of agreed matters. Mr. Crabb, you had your hand up next.
Yes, thank you, sir. I think our position would be similar to that of my learned friend, Ms. Coburn. We would have some concerns about the ecology part, but given that the expectation is that it's to be done in a week, clearly we'll take all efforts that we can to do that. And also, I endorse what Mr. Batten said about the coastal and the policy issue. One further issue arising is SIRS hadn't had a site visit yet. When would you expect to do that during the week? Would that be towards the end to allow, for example, issues that had been raised during ecology, for those matters to perhaps be seen out in the wild, so to speak?
Yeah, definitely. That's a good plan. Definitely leave it till the end. I mean, we may have the opportunity to have an informal little wander around the site just so we know what you're talking about when we're hearing it, but definitely an accompanied site inspection at the end of that week. We will come to the time of year. It's a shame it's not going to be in high summer where we can take as long as we like, but that will be the plan. So at the end of that week, I mean, I'm not averse to starting a little bit earlier and finishing a little bit later, if that gets us done in a week rather than everyone having to come back on the Monday or whatever. But yeah, we do need to factor in a site visit, and that's also going to be quite important. Mr. Burnett next.
Thank you, sir. I was just going to endorse the plan that is emerging to have the ecology first, and hopefully within 3 days or just running over 3 days. But I think that also indicates that it would be sensible to have it as a super hearing session rather than an inquiry session, because it's likely to be difficult to keep it to only 3 days or so if it turns into an inquiry session with everyone having cross-examination. So I certainly think ecology first for the majority of the week, followed by the tourism economy, and then hopefully have time for the policy and planning conditions, but they'd be the ones that might have to be carried over in that order: planning, then planning conditions, policy, then planning conditions.
Thank you. Yeah, makes sense. Mr. Finley's statement of agreed matters, common ground, mythical beast. I don't think I've actually seen one before, but I'm sure you've done one.
I'm told they do exist, and indeed I have seen them. But yes, no, we can try and do that. The extent to which we get there will be another matter, but we can try perhaps with the help of the council, and we can see where we get to with the coalition and other parties. But if we can narrow down policy matters in particular, that may no doubt be helpful. In terms of the site view, one other possibility is to have a site view in the weeks before, sometime beforehand, so as to inform your agenda session with a prospect of a further site visit, which could be much more focused if matters arose during the hearing session and afterwards, that would enable you to do that. Because as I have indicated, we're very keen to limit the actual hearing time, and if that would assist you, we could we would suggest certainly an initial site visit, perhaps a few weeks before when the nights are longer, and then with the prospect, if you needed, of a further site visit after the hearing.
Yeah, thank you. That's an interesting idea. Ms. Cohen.
I wonder if this might help. What about having an unaccompanied site inspection at your own convenience before the detailed or super hearing session takes place, and an accompanied site visit at the end, so that you can your questions can be tailored to the evidence that you have heard, and any matters that might remain in dispute or in some doubt for you. You can use that accompanied site inspection to further inform your views at that point.
Yeah, I suppose the risk might it that we end up with a lot of things to look at in that last day or evening, afternoon. Whereas I'm just thinking off the top of my head now, if Mr. Finley's plan was, if once we knew effectively where the parties were coming from, if we had an accompanied visit then, so once statements were in, so a few weeks before the actual session, people could then show us what they think we need to know. And it might be there are other things that come up from the discussion that they also want to show us, and then we can just go back. But as Mr. Finley says, that would be a much more focused, hopefully, visit. And given that, we might be short on time, that might be a more efficient way of doing it, albeit we would have to have, somebody on site with us, other than during that inquiry week, which I appreciate that's not necessarily convenient either. Things we don't really know what we don't know, or what people will want to show us. Maybe people can have a think about what they want us to see on site in advance, and we can get a feel for how much. I mean, it's not a massive site, but if you can get a feel for how much time it's likely to take, and then we can get a feel for, do we need to do the bulk of that up front, and then just leave unexpected clarifications for a short visit at the end of that week, maybe. Okay.
Yeah. So just to echo my point, I certainly think that a site visit after we've heard the ecology evidence will be very important to look at issues again. I mean, clearly we can all put in statements and anticipate things, but then when issues are properly examined, ventilated, given the importance of the site and the ecology there, my submission that it will be very important for the reporters to be able to return and deal with specific issues.
Sure. Yeah, I think I agree with that. It'd be nice if we could narrow that down. If maybe that's overly optimistic that we can never narrow it down, but if we've already seen things that we know are definitely where the parties are definitely opposed, it might be that we don't at the end of the session need to come back to look at all of those. It might just be there's a few. Ms. Cohen, you're on mute.
Thank you. I wondered when I would do that. I'm sure it's not beyond the wit of all of us who would be able to, perhaps as part of a statement of common ground, statement of agreed matters, to come up with some suggestions as to where you might want to go in advance of the ecology hearing session, certainly. And we're very open to providing you and other parties with some suggestions about that.
Yeah, and we might not need to be accompanied if the experts tell us, and they can trust us to look in the right place, which is maybe more to the point. But if they can tell us what they want us to look at, then maybe they don't actually have to be there before. And then, as Mr. Crabb says, if at the end of the session, they can show us what really needs to be looked at. But hopefully that will be more confined. If it'll come out that these are the real important issues. We'll see. Now, I think that was it. How long? So we've had a submission on where it should be, which I think was the Embo Community Centre. Does anyone have any other suggestions before I set our staff to have a look at that? Mr. Batten, you had a hand up.
I seem to recall at the previous inquiry that Councillor McGilvery was very keen to use Embo at that time. My recollection, and others may know this more than I do, was that the technology availability at EMBO was a little bit limited, and that was why it finished up being at the Clashmore Hall a few miles down the road. And that might be something for the case officer to look into. Maybe the positions changed at EMBO. The other thing, and I think Councillor McGilvery will also be aware of this, is that depending on the timing, if the inquiry happened to coincide with the general election, my understanding is that EMBO Community Centre is a polling station.
Right.
An unfortunate clash.
Indeed. I've forgotten about the election. I don't know if the council is still on the call.
A couple of hypothetical points at which clarification can be ascertained.
Thanks. Yeah, how we deal with documents is we will have a central online repository. Everyone will upload their documents to one central source, OneDrive, I think it is. And in theory, if there's decent internet access at the venue, nobody needs to actually have downloaded copies or hard copies. But in reality, most people will take the precaution of downloading anything they might possibly want to look at onto their computer. But even with that precaution, given that we would hope, I assume, to webcast as we try to do for everything, that in itself requires a reasonable internet connection. I mean, it's not, to be honest, that's I don't think an absolute requirement in that we can just record a thing and then upload it later on. We certainly couldn't stream it live unless you have a very good internet connection, but it is a factor that we take into account, is how good the internet connection is. And those in the office who know a lot more about that will be able to look into that sort of thing. But
especially if there are remote witnesses.
Yeah, if as I've indicated, we're happy for remote witnesses, but yeah, they very much do need to have a reliable internet connection, otherwise we come unstuck. So we'll look into that, but certainly that can be our option number one, unless we absolutely can't go for that. So we've done how long and where. Question now is when. I think we initially very optimistically said August, and everyone, well, I think it was the applicants team, said no, we're not around, which didn't entirely surprise us. So then we were straying into September/October/ maybe later than that. I'll look at you first, Mr. Finley, because
so
what do you think?
I believe that we would all be available for the week of the 9th September, if that worked for others.
It doesn't work for us, I don't think, sorry. As we need to be there, that probably kills that. That doesn't work for us, I'm sorry.
We're quite limited in September ourselves.
Yes.
Right.
Very limited. Apologies. Yeah, we did suggest September, and then having actually then looked at diaries, it became apparent.
We're hoping more August.
Do you have a fallback position at this stage?
Well, I think the week of the 26th of August has a bank holiday in it. I don't know whether that's a Scottish bank holiday as well.
I think that is a good one for us. Colin's shaking ahead as well. How about later?
I wondered if the first full week in October might suit parties, because I think there's going to be quite a lot of preparatory work that's going to be going on. I understand from some others that I think it's Monday the 9th of October might be a suggestion. I think the light, certainly further north in the borders where I stay, would be probably better longer.
Monday is the 7th of October, I think.
7th of October, then, yeah. Is it the first?
The week before,
the week before is not possible for our team, I'm afraid. There's 2 members of the team that are not available until the 6th of October would be the first available date for the main ecology witness. So that would be Monday the 7th of October.
Right, I think we're going to struggle in that week. How about the following week?
following week would work for us, so that certainly would be very grateful if that could be accommodated. Appreciate that this isn't set purely by our requirements, but certainly we have got considerable witness availability issues in September, extending into the first week of October.
Right. Mr. Crabbe, how is that?
Yeah,
suit you?
yes, sir. That would fit with our experts and with our team. So if that was possible, we would be grateful for the Monday beginning the 14th.
Mr. Burnett, any good?
It's all right for me. Some councillors and the planning officer have limited availability in October. I think that's straying into the school half term. So I don't know if other people may have difficulties in those middle weeks of October.
I guess you're there. I'm thinking what active involvement they would need to have. Obviously, it's a matter for you, but in terms of, I mean, I guess well, I don't know, but they'll be wanting to come along and support the proposal, presumably councillors in particular. I don't know whether they intend to be present in every session, or if we could work on.
No, so that may be the case. Although I think they'd probably like to be involved in possibly the tourism session, but it's more also the planning officer in terms of the conditions session, because they may have views on the wording of conditions that they'll be the ones that are left to enforce. So I do think that is a consideration. But if that session ended up being delayed, that may not be a deal breaker. But we do have difficulty in October.
Right. Okay. Ms. Ferguson, how are you fixed?
Unfortunately, the Nature Scout team was available for many of the previous weeks we have discussed, so including the 7th till the 11th. The following week, starting the 14th, one of the likely key participants in the super meeting section is unavailable indeed for the rest of October. Just to mention potential alternative dates, the Nature Scout team would be available the week commencing the 4th of November, 11th, 18th, and the 25th. So November would work for the Nature Scout.
Thank you. Martin, how are you fixed for November? You're on mute.
November's actually rather good for me. My principal interest is being able to keep my camper van on the road for reasonable parts of the year, and that tends to pack up by about mid-October. So that's good for me. I was conscious of the school holidays being a constraint in October. I think that's reflected perhaps in some of the comments of other parties. And thinking of your community evening session, I think it would be unfortunate having that at a time when quite a few people were away. So my position basically is the later the better. My principal concern is, as discussed earlier in terms of the written statements on policy, is in keeping the written evidence submission dates as late as possible as well, if that's helpful.
Thank you. Round and round. Mr. Finlay, I don't know if you've thought about November.
I don't think we had, so we need to double check availability. I know that looking at my diary, I am available the first 2 weeks in November, definitely 4th and the 11th.
I've got the 11th, the week of the 11th.
We're certainly around the week commencing the 11th. Seems like an awful long way away. So, Mr. Burnett, again, you probably don't know, but at least it's not in October, so maybe that suggests it might be possible. Yeah. Can we say 11th?
For me, and I imagine, hopefully, hang on, just getting an email. We can't guarantee it at the moment. We need to check about November, but it's better than October for us, and certainly I can be available in November.
Good. Thank you.
So perhaps I could, if it is going to be that late, could I reinforce my request for an early site visit and to have that at a time of year when it would be more conducive to seeing what's happening, and to reinforce the idea that it is quite a large site, so you may well be assisted by it necessarily need to be an accompanied site visit, but by being the landowner being able to assist you as to where to go and how to get there.
Yeah, yeah, we definitely prefer to have a look on site prior to the bad weather, albeit with the option to go back and look at things at the end of the inquiry week. Definitely, we'll factor that in. So, can we work the week of the commencing the 11th of November? Does that? I've forgotten who I've asked now. Does that appear to work?
Perhaps I could suggest that because we haven't checked our experts for then, that subject to us parties coming back to you within the next 24 hours, and that would be appropriate.
Sure. Yeah. I mean, we won't have the note of this meeting out before then, so that'll be fine. If looking at our availability, the subsequent week, I don't think we can do. But the week commencing the 25th, we can. So I don't know if if we had to, if we aim for the 11th, but if maybe, you know, if there's a major problem, if we could think about the 25th, if we had to, if that, you know, if we're aiming for the 11th, and that's we hear, and you know, if that doesn't work, as Mr. Finley says, if we can be told, you know, within the next day, that'll be great. And if not, we can start things moving. What else do we want to talk about? Yeah, contacting DPEA is Rebecca Davidson. You've probably already had contact with her, but you know, she'll be able to keep you right if you have any questions about procedure, or she's the person to send anything to. We will get the note of this meeting out as soon as we can. You know, by the end of the week, certainly, and that will contain procedure notice, which is a formal invitation to participate in further procedure, so written submissions and hearing sessions, to which you need to respond within 14 days to guarantee you don't miss the boat. So don't forget about it. Just a quick email response back to Ms. Davidson will confirm that you do want to participate in whichever session. That, I think, was all I had. Anything, Mr. West, covered? No. Anything, Mr. Finley?
It's just about the site visit. I gather you're not available in September, but I'm just canvassing your potential dates, say in August, to do the site visit. It may be something that we can liaise with your contact, but it may be easier to do that offline. But if August is a possibility for you and Mr. West, then that might be it. We can work on that and liaise on that with others as well.
The first week in August is.
Yeah, I'm very flexible. July and August.
All right. Yeah, I think we're okay. Certainly. Yeah, actually, July and August doesn't seem to be a problem. So yeah, hopefully we can try and sort something out. Yeah, we would probably try to do it completely unaccompanied. I hear what you say, Mr. Finley, about the size of the site and getting around it, etc. But and I appreciate the landowner isn't the applicant, but still, we prefer not to have anyone involved remotely with the case who would benefit, without, because then we'll have to start dragging the council and possibly objectors in, and so if we can do it completely on our own, but it would help certainly to know by whenever it is that we do it what main areas we need to be looking at, so we make sure we cover everything before we start the sessions in November. We'll have a think about that, and we'll mention that in the note as well, just to say what we're provisionally thinking about doing. Mr. Batten.
So two very quick final things. I mentioned the election And I have no insight into the Prime Minister's thinking, but I seem to recall the Thursday, the 14th of November being one of the dates more widely touted in the press, and that might therefore have a bearing on venue options. And the other question, I had a note to ask about core documents. Am I to understand from your description of the document uploading process now that since I was last involved with DPEA, core documents are no longer so much of an issue?
Yeah, we've tried to simplify the process. I'm not sure if that's the right word, but we've tried to make it easier anyway. I mean, there are documents that we already hold that are hopefully up to date and can form part, the starting point of the online records. Things like NPF4, for example. We don't need everyone sending us a copy of that. So it'll simply be parties adding to the list of documents we already have, things that they think are important and to which they want to rely. And rather than being sent to us, I'm now straying into technical stuff which I know nothing about. I'm not getting Mr. Ware, who also doesn't know anything about it. But they'll be stored on a website. You will get a password and you'll be able to upload things to that website, and that will be the document. So we won't have 15 copies of the same document. We'll have one copy which will be up to date, and everyone will be able to access it. And in theory, during the inquiry, everyone will be able to access it online. But as I say, it's wise to download it beforehand, so in case things go wrong. I'm sure Ms. Davidson will be far better able to explain how that all works than I, which isn't hard, but I know it does work. And I think parties find it slightly less onerous than in the past. And it avoids confusion as to, which PDF am I looking at? And mine starts on page 5, and it all gets a bit chaotic. So hopefully it'll all be seamless. But I will talk with people who know more about that, and we'll make sure we get some instructions out as to what you need to do and by when, etc. Sure, it'll be fine. Anything else anyone wants to raise before? Oh, yes, Dr. Dargy.
Can I just clarify one point, going back to item 4 on your agenda, additional information? Crab, our advocate, mentioned that there was a document which had been produced by C4C. He was a little bit unclear of where that was submitted to. It went actually to all individual councillors, members of the North Planning Applications Committee, in advance of their decision meeting on the 6th of December. So it was a one-page letter, individually named councillors, a 4-page summary, and a 60-page full document. And our interpretation of the contents of that is that it does contain new information, and it was referred to in the Planning Applications Committee debate. And therefore, it potentially has a bearing, and it would be useful if C4C would put that document to you. If they're unwilling to do so, Not-Coul does have copies of all this and will submit it independently. Thank you.
Yeah, thank you. I'm sure someone will give us it. I don't need you to answer now, Ms. Finlay, but all I wanted to raise was, if anything is, or if there's any sort of question mark as to whether anything needs to be advertised or publicised or whatever, then I'd sooner do it. But I don't know if you know the document to which Dr. Dargy is referring.
I may have seen it at some stage. I'd be very surprised if it contained new environmental information that needed to be advertised. But I'm very happy for Not-Coul to submit the document to you if they think it's so important, and you can take a view.
Thank you. Yeah, I don't mind who gives us it, but if anyone wants to rely on it, then please do submit that as part of your case. Anything else before we wind up? No. Oh, okay. Well, thank you very much. We got there in the end. Sorry, it was slightly chaotic. Hopefully, we know where we're going and we know when we're going. So 24 hours, please, from now, if you suddenly discover that isn't suitable. I'm sorry, that's our fault because we sprung it on you at the last minute, but week commencing 11th of November is what we're aiming for. But do let us know if that simply can't work, and we'll try and find something else. But assuming that's not the case, look out for the note of this meeting, and we will take it from there. Thank you all very much.
Thank you.
See you later in the year. Thank you.
Obliged. Thank you.